everybody. I'm Naomi Gillens on behalf of the HLS ACLU chapter. It is my great pleasure to welcome you to today's talk by Ben Weisner. We have a number of organizations to thank for making this great event possible. So before we get started, I'd like to thank JOLT, the National Security Law Association, the National Security Journal, CRCL, Unbound, and ACS. As you can see, food has not yet arrived. We're expecting it to get here, hopefully any minute, but I guess if it's okay with everyone, we'll just plan to take a quick 5-minute break when it gets here, and then hopefully resume the talk quickly because there is a class in here at 1 o'clock. So to go ahead and dive in, Ben has been the director of the ACLU's Speech, Privacy, and Technology Project since 2012. Prior to that, he spent 10 years litigating post-9/11 civil liberties abuse cases. He's appeared regularly in the media, he's testified before Congress, he's traveled several times to Guantanamo Bay to monitor military commissions proceedings there. In the last year, much of that work has been subsumed by his role as Edward Snowden's legal advisor. And we're very lucky to have him here with us today to talk about his experience. So please join me in welcoming Ben.
Thanks, but I saw the sign and it said conversation, not talk. And actually, it's much more interesting for me to have a conversation with all of you, so I'm going to keep my remarks very brief. Maybe it'll be timed perfectly to the arrival of the Thai food, and then after that, we can have a conversation. So is the microphone working okay, people in the back? Okay. So since I am at a law school, it probably makes sense to begin with a little bit of my own journey from being one of the people in one of those seats to being the person standing in front of this room. I graduated from law school in the spring of 2000. If any of you are 3Ls at the very end of the law school experience, there are all these contrived social events like booze cruises or things they might call a last chance dance, where you gather with all of your classmates. And we gathered in Windows on the World at the top of the World Trade Center on a foggy night. And it is a moment of real idealism when you're graduating from a great public interest law school like NYU, surrounded by so many people who are going to devote their lives to the service of people rather than the collection of property. You're about to go off on this career. I was about to go and clerk for the most liberal judge in America. And it really was a moment of incredible joy and optimism. And obviously a number of things happened pretty quickly in the years that followed that tempered that and changed my outlook a lot. The first of those, and it's really hard for me to overstate the significance of this event, is that during my clerkship year, and clerking is hard. You know, clerking can be very hard. You spend a lot of time trying to get the law right. You're confronted with legal issues that you've never seen before. It feels quite consequential because real lives are involved. You can't believe that someone who was in law school a year ago has any role in actually adjudicating these kinds of disputes. And in the middle of that experience, which for me was at least a 6-day-a-week job, the Supreme Court decided Bush v. Gore. And this was a real gut punch for people who took the law seriously. Because this was really nothing other than a brazen exercise of power without any tethering to judicial principle. This was a bunch of justices on the High Court who had decided what the outcome should be and worked backwards to a transparently and baldly false kind of legal analysis, and even said, don't ever rely on this again. I sometimes think that you can draw a line from the kind of reasoning, if you should even call it that, in Bush v. Gore, to the kind of reasoning, if you can call it that we saw in the torture memos written by people like John Yoo. This was not legal thinking the way that I had been taught to do it. This was not people who were trying to figure out what the law said about a certain problem. These were people who were bending the law and twisting it towards a very specific and at times very violent partisan outcome. So obviously, the second event, the shadow event, there are no more last chance dances at windows on the world, unfortunately. And I began at the ACLU in August of 2001, just about 5 weeks before the 9/11 attacks. I had gone to work for the ACLU in Southern California thinking that I was going to help reform the world's largest jail system, which LA County still has. And although I did some of that work, it was different jails and different prisons that ended up drawing me. Not just Guantanamo, but the network of secret prisons that the CIA set up around the world, to which they transferred terrorism suspects after kidnapping them off streets, and subjected them to what those memos might have called enhanced interrogation techniques, but you all know was torture and sometimes death. I spent many years litigating, or perhaps we should say trying to litigate, cases on behalf of victims of some of those practices. I sometimes joke, or I joked before I took this new job anyway, that a proper epitaph on my tombstone could have been, "He died without reaching the merits." And that's because, as all of you know, even though there are now classes in things called national security law, there isn't any real adjudication of these kinds of cases at all. When you bring a challenge in court to a torture program, or even a torture incident, to a surveillance program, to a watch list program, the government, which very loudly defends these programs as legal when it speaks to the press and speaks to the public, says something very different to the courts. It doesn't say the programs are legal. It says the programs are too secret to be litigated about. It says the defendants are immune and shouldn't have to answer. It says the plaintiffs have no legal standing to be in this court in the first place. Sometimes it says all of those things in the same case. And so, I represented very well-known torture victims. Khalid al-Masri, a German citizen who was kidnapped in Macedonia by the CIA in a case of mistaken identity, transferred to and tortured in Afghanistan, released for some odd reason in Albania. A case where you can read lots of books, you can read newspaper articles that quote, off the record, CIA and State Department and intelligence officials saying, "We made a mistake with this guy. This was the wrong guy." When we brought this case to court, not needing any discovery in order to build our case, with all the evidence that we needed in order to adjudicate this claim, every court that looked at this accepted the CIA's insistence that this was a state secret, that this was a case that couldn't be litigated. And the same thing, of course, happened with our surveillance cases. Most famously, just a few months before the Snowden revelations, my colleague Jamil Jaffer, a graduate of this fine institution, was in the US Supreme Court arguing a case called Amnesty versus Clapper, and this was a challenge to what we now know of as the PRISM program and the upstream program under the FISA Amendments Act. Again, the government didn't tell the Supreme Court or any other court that the program was legal. It said that the plaintiffs had no right to be in court because we had no evidence that we were subjected to these surveillance programs. We were not able to get that evidence because that evidence was categorically a state secret, and therefore neither we nor any other plaintiff could challenge the constitutionality of this program. And in a 5-4 decision, the Supreme Court said that our standing claim was attenuated, that it was based on a series of assumptions, that we hadn't presented any kind of evidence that we were subjected to surveillance. And I wonder if at least one of those 5 justices had some second thoughts when The Guardian and The Washington Post started publishing articles in June of last year. I walk you through this even though this is a conversation about Snowden. Because one of the things that we've heard so much in the last 9 months from critics of Snowden is he should have gone through the system. He shouldn't have made the unilateral decision to give this information to the media. He needed to go through the system. Well, what system? The system that he should have gone through is the one that I just described to you in part. And he had watched. He had watched as the federal courts had refused to adjudicate the legality and constitutionality of these programs, but instead had thrown them out. He had watched as his superiors gave false testimony to Congress, transparently false testimony. Now, people say that they were lying to Congress, but that's not exactly right, is it? The people who they were lying to in Congress knew the answers and didn't correct them. They were lying to us about these programs. It was not just that information was being withheld. It was that the American people were being deceived about what the state was doing. And in the first weeks of after these revelations, the refrain that you heard most often from the government was that Snowden wasn't a whistleblower, and we really had nothing to worry about here because the programs that he disclosed were legal, and the programs that he disclosed had been approved by all three branches of the government. I would say that those statements, or at least the latter one, is the strongest endorsement of why Snowden had to do what he did. It's absolutely right that, for example, the NSA's bulk collection of the telephone metadata of every single American phone call had been approved by a secret FISA court, had been briefed to a Congressional Intelligence Committee, had obviously been approved and devised by the NSA itself. But what happened yesterday? What happened yesterday is that the president said, we're not going to do this anymore because we don't need it, and we have some questions about its legality. What happened a few months ago? A federal judge in Washington said this program is Orwellian and almost certainly unconstitutional, and there's a couple of other cases going up that are litigating that program. Not one of these judges has questioned the standing of the plaintiffs who have brought these cases to court. These documents have been our tickets to have our traditional oversight mechanisms actually function the way that they were intended to function. So I would say that precisely because the very same programs that were approved in secret are now being challenged, withdrawn, questioned, once the public has been brought in, explains why it is that Snowden needed to do what he did. Just a few more words about him, and then I really would like to hear what you guys want to talk about. I first learned his name the same day probably that all of you did, when that remarkably articulate interview, really wonderful video, appeared on the Guardian website on June 9th, shot by Laura Poitras, and the interview was conducted by Glenn Greenwald. I certainly knew long before then that they had been talking to a confidential source because Laura and Glenn are both friends and colleagues of mine. I knew that they were flying to Hong Kong to meet someone who described himself as a senior intelligence community official. I don't think any of us thought that he was going to look like our younger brother's younger brother. We were expecting something very, very different. And I first had direct contact with him in July after he had already left Hong Kong and was stranded for 39 days in the transit zone in the airport in Moscow. And one of the very first questions that he asked me, if not the first question, I don't know, it wasn't an email, we didn't save it, was, do you have standing now? And I was very moved by that question because it showed that what he was interested in doing was not undermining our systems but revitalizing them. He was not trying to trash the system. He was trying to get the courts back into their game. I think in his wildest dreams he didn't expect that within 9 months not just the courts would be involved, but the president himself would have appointed executive review panels that have essentially all concluded that the NSA went out of control and was allowing its capabilities to drive its practices rather than having its practices constrained by law or values. I don't think that he believed that there would be bipartisan legislation in the Congress that would impose the first meaningful restraints on intelligence surveillance since the 1970s. I think he hoped that the courts would hear these cases, and I think he also hoped that his fellow technologists would wake up and would respond to this very different threat model, perhaps, than the one that they thought that they needed to protect users from. And that there were things, and he still believes this, that the technology community can do to make mass surveillance more difficult, more expensive, harder to accomplish without waiting for people in Washington or Brussels or anywhere else to legislate. So, one of the things that people ask me, and I will anticipate this question, is what does it mean to be a legal advisor to Edward Snowden? What case are you involved in? What court is he in? What are you doing? What do you do all day, right? It's true that he has been charged with very serious espionage offenses in the Eastern District of Virginia. It's equally true that he will not return to face those charges. That he believes, and I believe, that the way that the Espionage Act has been used by the government and approved by at least the lower courts, not the Supreme Court yet, is unconstitutional, insofar as it essentially creates a strict liability offense, that there's no meaningful way for him to come into court and say that what he did was in the public interest. There's no requirement that the government justify the classification decisions that it made in order to keep these programs secret. It helps him not at all that there is this debate in Congress, that there is this litigation that's going on, that the president has canceled a program. All of that is irrelevant in a prosecution under the Espionage Act. The only thing that's relevant is that he was in a position of confidentiality with the government, and he broke their rules. Now, that's not the way that the Espionage Act ought to work. It probably ought not even to apply in cases like this. But that is the reality, and that's the basis for his claim of asylum. Having said that, I hope he will be able to come back to the United States. There are certainly circumstances in which he would. Those circumstances have not been presented to us yet by the people with the authority to actually make it happen. In the meantime, I hope there are other countries other than Russia that will, have the courage and the backbone to invite him to reside there. He would accept those invitations if they were offered, and I hope that the U.S. will have the wisdom to see that they should not stand in the way of something like that. It would be in everyone's better interest, even if he's not to return home, if he could live in a country where the U.S. has better relationships than it does with Russia. So what's unusual about this representation, again, is that it's not a daily litigation, but it's also not solely devoted to the client's protection. Remember, if this is someone who wanted only to be safe and secure, he'd be in Hawaii making $200,000 a year. This is someone who obviously put principles and ideals ahead of his own personal situation. And he doesn't want us to do anything that would harm the reform efforts, even if it would help him. You do not see him out on TV talk shows promoting himself. He has not sold a book or a movie deal, and what he talks about every day and wants to talk about every day is what can we do to help the efforts in Congress, to help the efforts in Europe, to help the efforts in the courts, to help move this along, and to help other people who might be in my situation someday. So it is an odd job. I spend a lot of time as a gatekeeper. We get, as you can imagine, a dozen media requests a day. If the answer to all of them was going to be no, it would be an easier job. But the answer sometimes is yes. So these are things that we have to discuss. In what form will he speak? What will he talk about? Will he issue a statement? Should he issue a statement in response to the president's announcement yesterday? Maybe he will. And that's something that we'll talk about later today, is what he might say in response to those things. Should he testify before the European Parliament? Should he testify before the Council of Europe? If so, under what circumstances? So that's sort of the daily work of I guess you might call it Team Snowden. It's remarkable work. It's remarkable to see also how the public over time is beginning to see the Snowden that I have seen since July, and I think that's reflected in not just in poll numbers, but in the kind of respect that he gets, at least in some institutional quarters. I think that his detractors overreached by hanging a spy label around him, by suggesting preposterously that he might have been working for Russia and China while he was at the NSA, and it's impossible to disprove any allegation like that. If one is called a liar, it's not usually a great defense to say, no, I'm telling the truth. But I do think that most people realize that this is something, even if they question his judgment about certain things, that he acted with complete sincerity and patriotic impulse. So with that, who would like to ask the first question? Yes?
I was just wondering have there been any specific challenges in terms of being able to communicate with Mr. Snowden, and how is that?
Has Thai food arrived? All right, perfect. Let's take a break. I'll see you all in 5 minutes. So yes, I think it probably makes more sense for us just to resume, and people can get their food quietly. But this way, I'll have a chance to answer a lot more questions than if we wait another 10 minutes before I start. So the first question that was asked, just as we were breaking up, was, is confidential communication with Snowden difficult? And it's a hard question to answer. Because if you have an agency that spends tens of billions of dollars trying to be able to get around any kind of cybersecurity, any kind of defense that you use, you would be crazy to have confidence that you've defeated this kind of adversary. And of course, the NSA doesn't have to break through encryption in order to read communications. It most commonly will break around it. It can hack into our endpoints. And I think that if the NSA has undertaken the legal and political risk of trying to intercept an ACLU lawyer's communications with Snowden, then they're succeeding in doing so. I say if, because I do think that it is probably unlikely that they're doing so. This is not a lawless agency that has absolutely no respect for the rule of law at all. If the NSA were going to intercept my communications, it would have to be a very, very compartmentalized effort. Because if something like that were to be leaked to the public, it would be more devastating for the NSA's authority than anything that has been leaked to date. It would be targeted surveillance of an American lawyer representing a client, and I don't see that as a likely threat. It's certainly one that we have to take seriously. Bart Gellman of the Washington Post has said that he is more concerned about efforts to hack him by third countries than he is by the United States. He has to worry about China, he has to worry about France, he has to worry about Israel, he has to worry about Russia. I feel the same way, that it's more likely that one of those countries would be trying to intercept my communications with Snowden than that the US would be doing so directly. Having said all of that, we can't discuss anything, even over the most encrypted channels, that would be dangerous to him if it were intercepted. We simply cannot do that. So there are some things, surveillance is, in that sense, attacks on the attorney-client relationship. We do the best we can. He is awfully good at security. One of his jobs in the intelligence community was with the DIA to train US officials who were going overseas into environments like China and Russia on how to protect their information. So he certainly knows the NSA's bag of tricks, but because he knows it, he knows that he can't be sure that our communications are secure. Having said that, when I travel to Russia, we also similarly can't be sure that the face-to-face conversation that we had wasn't subjected to surveillance. That's the reality of the world we live in right now. We do the best we can. We have different ways of communicating for different levels of sensitivity, but at the end of the day, we have to communicate. Yes?
So you mentioned the possibility of Snowden finding a more permanent situation in a country with more friendly relationship with the United States. And also the possibility of him testifying in front of the European Parliament. And from what I've read, there's kind of an idea that he's stuck. Even though Venezuela's offered to shield him, he can't actually leave. And also for him to go to a country with a better relationship with us probably needs that extradition agreement. So how feasible is that?
Yeah, so for benefit of the recording, the question is, how feasible would it be for Snowden to leave where he is now to go to a third country? Under what circumstances? I think right now it's not feasible, is the answer. I think it would be madness for him to go to, say, a Western European country unless the United States had indicated somehow that it didn't object to that kind of move. Because as you say, and there's an Interpol warrant out. I think, now, that wouldn't supersede a grant of asylum if it was offered. The Danish parliament is voting on whether to offer asylum. I don't think the vote is going to pass, but if it did, that would be a different kind of situation. We don't think that it's safe now for him to travel from where he is to Venezuela or Ecuador or Nicaragua, the only countries in the world so far that have offered asylum, precisely because we've seen the lengths to which the US government will go to prevent that from happening, including grounding of the Bolivian president's plane in Austria, not letting it fly through European airspace. So none of this is on the immediate horizon. These are the goals. I don't think it serves anybody's interests for Snowden to be where he is right now. Not his, not the US government's. And I hope that they can see beyond that. I think that there are people in the intelligence community who would rather be able to take potshots at him for being in Russia than to actually work with us on a constructive way to change that situation. Sir.
Thanks for being here, and I appreciate what I call him Lord Snowden. I appreciate what he's done and what he's doing. Apart from the surveillance issues that you just talked about, what would you say are the range of forms of pressure, including subtle, perhaps more subtle inducements that have been brought to bear on you or your client to try to induce a change in trajectory in terms of his stance and his continuing effort?
Yeah, I'll answer that, and the answer is, if there were subtle inducements, they were so subtle that I crudely ignored them. I felt very free to do this work, not under any pressure. I acknowledge it is a lot easier to be a human rights lawyer in Brooklyn than it is to be one in Moscow. It is still, in remarkable respects, a free country to do the kind of work that we do, and I think the debate that we've had in the last 9 months is the debate that we should have had before these disclosures, but it is a real democratic debate, not one in which I feel like I am being intimidated by dark forces. Yes?
You, in what I can only assume was you misspeaking, suggested that the decision by Russia was courageous.
No, I said that?
You just said that they're taking the courageous step of offering him asylum and you hoped other countries would.
No, I didn't. Actually, did anybody else hear that?
I'm sorry, my mistake. But could I ask you, do you believe it's ironic or illegitimate for Edward Snowden to seek asylum in a country that is, after all, responsible for the most asylum cases in Western Europe, against a country that, after all, has a set of rule of law that you...
Well, asylum is not against a country. Well, I mean, I suppose asylum is against a country in this sense. Probably in 2004 or 2005, let's pick these years, or 2003, hundreds or thousands of people sought asylum in the United States because they were fleeing torture in their respective homes. I don't think anybody called them hypocritical because the U.S. was torturing prisoners in Abu Ghraib, or because the U.S. was operating secret prisons around the world, or because the U.S. had Guantanamo prison open. And I don't think that there were big rallies of asylum seekers in the United States who were denouncing those practices, even though they themselves were torture victims and they were fleeing regimes. Asylum is not endorsement. And so I do think that to say, look, there's an irony, for sure. But I want to say two things about this. Number one, quite obviously, the problem that Snowden wants to talk about is the problem of mass surveillance in free societies, right? There is no suggestion of equivalency, superiority, and he has denounced mass surveillance everywhere if you actually look at his statements. But he's much more concerned about countries like the United States that have something to lose than he is about societies that are already less free. If there were anywhere else in the world where he could be, he would be there. Remember when he was stranded in the transit zone in Russia, he applied for asylum in more than 20 countries. The only ones that were able to offer it to him are ones that he cannot travel to safely. He would prefer to be elsewhere. But I think to say that because Russia is in many respects a surveillance state, Edward Snowden should spend the rest of his life in prison, to me, isn't a logical or principled response to the problems in Russia. Maybe you disagree. Yes?
Thanks for the presentation. Thanks for your work. I was wondering if you could speak to another defense that the administration kind of states about the programs. And one of them you said was all three branches of government. A typical one that is often stated is about how the programs are targeting non-U.S. persons. They're abroad and so on in large degree. And I understand that that's partly because of the way the law is structured or how they believe it is structured. But just in general, I think as a defense of the programs, it strikes me personally as disturbing to say that this program is okay because, don't worry, it doesn't touch the people inside the United States.
Well, I think you've actually heard that less and less. This was one of the sort of loudest refrains in June and July. Don't worry, we do a better job protecting Americans' privacy. And I think the reason why you hear that less from the government is not only because of the sort of loud protests of foreign leaders of Brazil, of Germany, and elsewhere, but perhaps even more the loud protests of the wealthiest technology companies in the United States and in Silicon Valley. When you have people like sort of the Googles and the Facebooks of the world calling up the White House and saying, please stop saying that. That's really not helping. We are global businesses. We're trying to reach a global audience. And for you to say, don't worry about it, we're only doing all of this stuff with foreigners' data, that's not. So I think that more than anything is responsible for that change. I'll say, again, a couple of things in response to this. Often that distinction is invoked in order to delegitimize Snowden as a whistleblower. And again, I don't want to get into any kind of semantic debate about what whistleblower is. If you define whistleblower as only someone who reveals government activity that is illegal under current law, well, then obviously Snowden is not a whistleblower, because many of the activities that he revealed are considered or were considered legal under the current law. That's part of the problem. But this distinction that the American people only had a right to know about NSA surveillance at home, and the secrecy was just fine as long as the NSA took place abroad, has always been a mysterious one to me. And the NSA is a very significant branch of the United States military. I don't think that we would say that the American public only has a right to know about illegal wars, but as long as the wars are legal, that's really fine. I mean, the question is this information that the public in a democracy should have in order to consent to it and authorize it, not is this illegal? And I think it can be said about the information that has been published by journalists, and I'll make this point again, Snowden hasn't published a single document. Everything that we know because journalists and their editors have decided to publish this. This is information that the public had a need to know. And the proof of that is in the policy changes that have taken place. President Obama in January, when he gave his big speech about the NSA, was the first president in history to say we need to change the way we do intelligence surveillance abroad. Overseas. The president said it himself. And the proposal is to respect the Privacy Act even for data that isn't covered by US law or Constitution. There's going to be changes in our overseas collection. I haven't even sort of gotten into the question of privacy as a human rights issue and one that should transcend domestic law. I do think there are distinctions between domestic intelligence gathering and foreign intelligence gathering. I think it's different if the government that's collecting the information on you also has coercive authority over you. I think there are different kinds of considerations that are in play here, but I think mostly have been gratified by the direction of that part of the debate. Yes?
I was wondering if you could talk a little bit more about the composition of Team Snowden. Does he have legal counsel in Russia, or are there other people you're working with?
Yeah, there are a few other people. So there is a lawyer in Russia who is the point of contact with ensuring that he has secure asylum there. I don't know that I would call that person part of the team because we don't coordinate and we're not involved in the same efforts in that sense. He needs a lawyer in Russia who is capable of dealing with that system, and no one here is able to do that. There are obviously criminal defense lawyers because he's facing quite serious charges, and so those are the people who are the point of contact with the government when that's necessary and would represent him in the event that his asylum were revoked and he ended up back here. And he is also represented by a human rights lawyer in Berlin who has been coordinating the work in Europe, whether he's going to testify before commissions, whether asylum might be a possibility in those countries, by a human rights lawyer from Guatemala, who is the point person for efforts in Latin America, and by a whistleblower lawyer from the Government Accountability Project in Washington, who is very familiar with the essentially the laws as they pertain to someone in his situation. So there's a lot of, there's a number of people who are working on this. I'm only really comfortable in describing my own role here, but those are who the other people are. Yes?
I wonder if you could discuss Snowden's actions as actions of civil disobedience, which has a long history in the United States and has been a really effective way over time to make our laws match our ideals and principles. And so is that something that's, is that an idea that gets traction in your team, and what does that mean for being a lawyer on that team?
Yeah, it's a good question. Of course, there's different models of civil disobedience. I think the one that people who are most frustrated with Snowden invoke is the one of people, sitting in the street and being led off to jail. Martin Luther King in the Birmingham jail. You're not happy with the law, but you live in a democratic society, and so you submit to it and hope to change it. But that's actually not the only model of civil disobedience that we have. I mean, there's the Underground Railroad model. I don't think anybody said that we should just submit to the Fugitive Slave Act. And it's a democracy. We'll change it eventually, right? I mean, so there are cases where civil disobedience or disobedience to the law means breaking the law and not accepting the consequences of that, and there are cases where it means accepting the consequences. I think that if the penalty for what Snowden has done were remotely reasonable, he would have gone to a lawyer's office instead of to an airport. What he had seen was the opposite. What he had seen was that the law created exactly the wrong incentives by equating espionage with whistleblowing. One could get a sentence of 35 years I think Snowden's could easily be longer than Manning's if he went to trial. That the law didn't allow him to defend himself on principle. But sure, I mean, this isn't it's not a typical case in this regard. Although I guess what I would say is, perhaps there's a reversal of roles between the ACLU and the government in this case. For the last 10 years, we were going to court and saying what the government is doing is illegal, and the government's response to the court was, don't look. And now the government is going and saying, hey, what he did is illegal, and we're saying buzz off, right? I mean, if they, to me, the real hypocrisy, the real irony, is people who authorized torture or didn't do anything about it, standing up and banging the table and saying, "How can we let this person get away? Rule of law, rule of law." Are you kidding me? I mean, Washington is full of people who are not subjected to the rule of law, and people who didn't do anything in the public interest, people who broke the law with impunity, tortured and killed prisoners. So, it doesn't trouble me that much. Really? Yes?
I don't know if my question amounts to more of a request for a pep talk for disillusioned law students, but I agree with your earlier statement that some of the real change is coming from the tech side rather than the legal side. And now that I'm in jail, I spend 3 days a week just at MIT trying to interface with those people and think, how can I help them anyway? What would you say to someone who wants to find out how to, wants to reinvigorate their belief?
Well, let me stop you. I mean, if the last 9 months haven't given you some cause of optimism, I don't know what will. I mean, around our office where this work is really hard, where you have to do it year in and year out, even though you're getting tossed out of court with legitimate cases, morale is pretty high. Why is that? The first case that we brought, based on the Snowden documents. The first document that was published was an order from the Foreign Intelligence Surveillance Court to Verizon Business Records saying, turn over all your telephone metadata on all your customers every single day. Well, we're one of those customers. The ACLU is one of those customers, and we were in court within days. That case was dismissed. I think that dismissal will be overturned on appeal. But the court acknowledged that we had standing to be in court. We were in court arguing about the Constitution. Not arguing about state secrets, not spending all our time arguing about standing. We were actually in court arguing about the Constitution, and courts are going to adjudicate the legality of these practices. It's incredible that I say this as if it's a tremendous accomplishment. But this is what happens sometimes. Sometimes you need somebody to work around the system in order to fix the system. And I really do think that that's the dominant story of the Snowden disclosures, is not that he blew off the system, but that he helped to save it. And that these issues that were languishing in a secret federal court that only heard from the government. It's fine to have a court like that if it's just going to issue warrants. But if it's going to write 60 and 90-page opinions that are evaluating the legality and constitutionality of these programs, it should hear from someone other than NSA officials and their lawyers. the Congressional Intelligence Committees would sit there and allow national security officials to lie to them and not correct the record. The full Congress wasn't aware of all of this. The author of the Patriot Act says that he was surprised when he opened up The Guardian in the first week of June to see how it was being used. Now you see all of these institutions actually doing their job, right? You see an energetic Congress that is probably going to legislate here. You see internal reforms that are being pushed in the executive branch. You see courts. To me, there's a lot of reason for optimism. And if anybody thinks that any of this would have happened had Snowden not done something dramatic, I don't really know how to respond to that. Yes?
I wonder if the deeper question is about lawyers' ethics. At every point about approving torture, the fires of courts, at every point the officials have gone to lawyers and asked for their legal advice, and lawyers have said, figured out a way of saying it's fine. So is that the issue?
Is that?
Are we guns for hire that will eventually you'll find someone who will justify legally almost any proposition?
Well, I think in the torture case that the lawyers were part of a criminal conspiracy. And I say that seriously, that the lawyers were enlisted by executive branch officials who had decided that they were going to do things that were clearly illegal under U.S. and international law, and that those memos were written as golden shields. I didn't use that word. Your colleague Jack Goldsmith used that word. And I actually think that was criminal, what they did. And the only way that you can break that conspiracy would be to go after the lawyers, because you had a perfect way, the people who carried out the torture said that they were only following orders. The people who gave those orders saying they were following the advice of counsel. The counsel said, hey, we're just lawyers, right? You can't get us, right? And everyone's off, and no one's responsible for it. Well, I think they're all responsible for it. So I don't think it's just a question of ethics. I think in this case, the lawyers who wrote those torture memos should be treated like mafia lawyers, because they knew that if they didn't know that what they were doing was illegal, they shouldn't be members of this profession. Now, that doesn't mean that I think that John Yoo should have his tenure revoked. Tenure is a different matter. Bruce.
So how does this end? And I don't mean for the man. I mean for the documents. How does this all end?
You'd have to ask the journalist, because I don't have the documents. You've seen them. I haven't, Bruce.
Yeah, but it's
I don't have them in my possession.
I'm just curious if you've been thinking about it too. How does this end?
Well, look, I think that we're in. If this is a football game and there's a first half and a second half, we're in the first half. As you know, having looked at these documents, these are not elegantly written RAND memos like the Pentagon Papers. These are, I've heard, PowerPoints, diagrams, very confusing, documents. And to report out an important story like Bart Gellman did a few months ago about how the NSA was hacking into unencrypted transmissions between data centers overseas. You don't find a memo that says that. You got to look at 16 different documents, then do some reporting. And so the low-hanging fruit is probably mostly done. And now there's going to be a grind as these journalists work through the stories. They all tell me that they have big stories still to report. I'm sure they tell you the same thing. How does it end after that? I guess at a certain point, they will decide that they have exhausted the public interest reporting that can be done from these kinds of documents. I mean, the NSA is a laboratory for sources and methods and vulnerabilities. 3 years from now, the stuff that they have is not going to be as newsworthy or interesting, right? I mean, you know that, I think, probably better than I do. They manufacture this stuff all the time and create new capabilities. So I think it will go like that, right? I mean, with the reporting side of it. We'll see what happens with the democratic government side of it. We'll see if these cases get to the Supreme Court. We'll see if Congress really votes, in the full Congress on these reforms. We'll see what the executive branch implements on its own. We'll see how the technology community responds. And I think, one story of the last 9 months is that the technology community has already responded. Communications are already more secure now than they were before the Snowden revolutions, right?
Yeah, you were one of your sentences that stuck to me is that you're very excited because now in the courts you're no longer arguing state secrets, but actually the Constitution. So my question is, doesn't the Constitution in itself, and especially the Fourth Amendment, give pause to excitement in that sense because there are so many legal loopholes that enable whatever practice you have in mind. And I'm especially thinking about Executive Order 1233, which the ACLU does fantastic work on, by the way, getting the information out. But in the interdependency of legal and technical loopholes, actually. And you mentioned just now the muscular case and where you actually don't commit the surveillance in your own country but abroad, rewiring an assumption of non-US personship or citizenship. So that's a factual statement, and my question is, how do you see the Fourth Amendment evolving given the fact that technology has got this?
So your factual statement is correct. Constitutional litigation is a limited part of any solution, but I think a critical part. But obviously it's not going to answer all the questions, especially at surveillance that they say that is targeted abroad, or at their activities that are authorized under wholly different authorities, including some of their hacking and their upstream collections. The Supreme Court isn't going to save us, but I think it's an important part of it. Will we have a Fourth Amendment for the 21st century? Right now we have a Fourth Amendment for the 1970s, right? I think the Jones case in 2012, the Supreme Court's GPS case, could be a good harbinger. Depending on how the court gives life to that case, it could end up being the most important Fourth Amendment case since Katz in the 1960s. The government's argument about GPS was, are you kidding? How could you have a reasonable expectation of privacy in a place where you drive your car around in public? It really made no sense to the government. They were shocked to be in the Supreme Court in the Jones case. But I think the court appreciated that there is a difference between a government that has to assign teams of agents to follow somebody around and a government where one agent at a laptop can track hundreds or thousands of people in real time over a long period of time. It's a fundamentally different legal question, even if the experience of the person driving around might be the same in the moment. And the key moment in that argument was when the Chief Justice asked the government's lawyer, are you saying that you could go into the Supreme Court's parking garage and put a GPS device on any of our cars? And the government's lawyer said, hey, that would be no different than our following you around with teams of FBI agents, which was the wrong answer, right? Right. You're learning a little bit of law as well here, right? Wrong answer, bad answer. No, but I do think we're facing the same kinds of issues with it's only metadata, right? So it's one thing if you're putting a trap and trace pen register device on a single phone of a single person and getting the to-from information from one person on one day. It's quite a different thing. I think not just in degree, but in kind. When you're getting all of that information on everyone and storing it for 5 years and have supercomputers that are figuring out what the associations are and hops and building social networks out of it. And you might even say that if you're dealing with content versus metadata for one phone call, Bruce, I wonder what you'll think about this. The police would probably rather have the content of one phone call than the metadata from one phone call. But if you're talking about 100 million, they would definitely rather have the metadata than the content, right? There's nothing they can do with that content except do a keyword search for Al-Qaeda or something like that. But Al-Qaeda's not saying Al-Qaeda, right? when they're talking on the phone. So I actually think that the law is exactly backwards when it comes to this. That the Fourth Amendment needs to give greater protection to mass collection of metadata than it does to content in the world that we're in right now. And I hope that the court will see through that. I mean, we in these legal cases, we are assisted by the top technologists in the country. We have declarations from computer scientists about what metadata can do and the power of it and why it's not a 1978 pen register. So I do think it's still an important front.
Short follow-up. Do you, in the shorter term, expect more from Congress or from that side of the legal process than in courts, or what are your ideas?
In the legislature or in the courts, I think it's a dynamic issue. I think that if a federal court of appeals, if the Second Circuit Court of Appeals or the DC Circuit Court of Appeals, well, actually, so what I really ought to say is, I don't know what the effect of yesterday's announcement by President Obama is going to have on these cases. I suspect the government will say that it ends them, that the program that we are challenging in courts no longer exists because they're not going to do this bulk collection. So I think that's going to be the next fight. But it's always dynamic. A good legal decision gets the attention of Congress, and Congress might do something about it. Something that happens in Congress resounds, is heard in the courts. The courts are looking and watching. So I do think that there is this sort of dance between the executive and the Congress and the courts, to see who's going to act and then to see how the others are going to respond to it. Yes?
Are you working with any international experts or foreign governments to get more political leverage to get all the changes that you want here in the system?
And you're talking about surveillance. So are we working with foreign governments or foreign NGOs or foreign actors? Yes. I mean, I think there have never been more meetings between, sort of U.S. NGOs, foreign NGOs. We've testified before parliamentary committees in Europe. The ACLU has, and other organizations have. We meet with visiting parliamentarians from those countries all the time. There are meetings in Berlin and London, elsewhere that are taking place, and I think partly that reflects that there aren't really domestic solutions to most of these problems. We're going to need to have different kind of global understandings about, what the limits of mass surveillance of innocent people should be, and it doesn't do a whole lot of good if you legislate it here and not here, given the kinds of intelligence sharing agreements that these countries have with each other. So yes, it's a hugely coordinated effort. I personally am not doing a lot of that just because I don't have time, but my colleagues are.
We should get out of this classroom, I think, but Ben, can you stick around for a few minutes
Yeah,
outside?
sure.